Warm welcome to the Luxembourg Center of European Law. On my behalf, I'm Professor Konak. I'm the acting director of the Luxembourg Center for European Law. But originally, I was also Max Planck Fellow when I joined Burkhardt and Hélène in 2020. And as you know, the Max Planck has been transferred to the university, and I was appointed acting head. And in this capacity, I have to say, I did all my best so that this wonderful project, the Comparative Procedural Law and Justice project, which gathers so many esteemed colleagues from all over the world, could carry on, peacefully and successfully. Success is yours, of course, but at least I try to make sure as much as possible that you had all the support you deserve for this wonderful project. I'm not in the field, I have to say. I'm doing banking and financial law and company law, but I'm happy to learn always from others. And I would like to say a few words about the project, which I think shows what is the best in academia. We are all academic in the room, and we should be proud about this achievement, because this project combines different elements which really are what we all aim for. First, it's a part of a chain of knowledge. You don't build knowledge alone. So this project, which is international, is first a long-term project, because I understand it was 4 or 5 years, if I'm correct? 5 years. 5 years, exactly. This was my recollection. And it shows that to achieve something, you need time. Energy, cooperation, dedication to achieve this closing conference, to get to this point. So congratulations to all of you for having done this. This is what we all aim to do something which goes beyond ourselves in cooperation and which takes time. And also have to congratulate Enrique, who was also working here, who has been working behind the scenes a lot. You know him more than me, but for the little I've met him, it was always such a pleasure. So Enrique, welcome back also to the center. And also what I think embodies the values of academia, cooperation, effort, on time. In a TikTok society, we're not TikTok people, hopefully. We will do some LinkedIn posts, however. So we have to sacrifice to the gods of social media, but it would be a small sacrifice. But it also shows a space. You come from all over the world. So this is unique. A project of such ambition, spanning not just across times, but continents, an academic adventures, which ends up here and now with this wonderful event. Everybody has contributed to this. So this is what academia is about: working together, cooperating, exchanging ideas, discovering new fields, going further. This is what you have achieved. And I'm sure you should be very proud of yourself. And the last point on this is I have to congratulate Professor Burkhardt S., because no ship sailed without a captain. And I can say I've been myself in his position of acting director. I know what I mean. But you need only exceptional people can gather so many, top colleagues. You have also to work with the egos, maybe, of some. And for this, only few people can achieve this. So I want to pay tribute to the dedication, leadership, competence, expertise of Burkhardt S. And with this, which you have achieved a wonderful project, I'm happy to have been able to contribute that he carries on. Also, I want to thank the FNR, who is somewhere in the room now. Yes, thank you very much for the support from the Luxembourg government for this project, which will shine on the world. And on this, Burkhardt, congratulations. You are probably one of the only people who can do this in the world. We're very privileged that you did this. I'm privileged that, I've met you. And of course, I wish you a very successful event here in this new center, which is a continuation of the Max Planck Institute. Thank you.
Dear colleagues, few words. 5 years ago, when Enrique Valines told me about the CPLJ project, I was fascinated and overwhelmed by the magnitude of the task, as I am today. This project is one that every civil procedure academic would have dreamed of. But it's a bit like the books we would like to write, but we don't, because it's too ambitious. It's too vague, it's too big, because it takes too much time and we have other things to write, to do. Yet, they did it. Enrique Valines, Loïc Cadier, Margaret Hu, and Bogart Hess have succeeded in building and carrying out this project, making this academic dream a reality. I remember at the midterm conference dinner how sad and moved I was when Professor S announced his departure and the end of the MPI here in Luxembourg. And I know that I was not alone. But today, I'm thrilled to welcome so many esteemed colleagues, scholars, practitioners to this final conference of the CPLJ. Your presence here today underscores the global significance of this project. The MPI and CPLJ were transferred to the University of Luxembourg between October and January. The university has taken on the responsibility as the coordinating institution. But, as in Visconti's Gattopardo, the leopard in English, le guépard en français, everything must change so that everything can stay the same. I would like to thank the editors, Professor Hu, Professor Valines, Professor Cadier, and Professor S, for their visionary leadership and unwavering confidence in the CPLJ, and to thank them for their confidence in the completion of this project and the organization of this final conference. I would also like to thank the Fonds National de la Recherche, FNR. Thank you, Mr. Ruby, for supporting and funding the CPLJ and for facilitating this strange transition between two institutions. And finally, she's not here, of course, but I would like to thank Séverine Mariani, whose meticulous organization and dedication have been crucial to the success of this conference. And finally, well, I know there's too many finally, but finally, I wish to thank each and every one of you for your commitment and contribution. Together, we have shaped the project that we have dreamed of, and that will leave a lasting mark on history of comparative civil justice. Merci et bravo, Professor S.
Dear colleagues and friends, participants in CPLJ, a very warm welcome from my side. And in the name of all the co-editors, Margaret Wu, Enrique Vallines, Séverine Ménétré, and Loïc Cadier, who unfortunately could not make it because he is sick today. And before I say something about our project, I would really like to express my gratitude to you all, to the co-editors, to the different teams that have been working in this project. It is and it was an ambitious project, and we finally were able to make it. And I'm very happy to see you all here in this room. And I know that there are many personal efforts behind the project. And for me, it was a wonderful experience to see that I'm not alone with my dreams somewhere propelling around, but that there are people taking it up, helping me, backing, and looking at the project, because this is why we are here. We had something to do. There was an interesting idea. It was something of our generation to be given to future generations. And let's look at the project, let's look at the different parts, what we have done. And finally, and this is also my idea of today, we should also ask how shall we continue with such a project? So, where does procedural law stand in the first half of the 21st century? What did happen? And what did we experience during the last 25 years? And what will be happening in the years to come? To what extent have political, economic, technological, and societal developments of the last decades impacted on dispute resolution? Is it possible today to look scientifically at procedural law and dispute resolution from a global perspective, as we are living in an area of globalization? What are the core values underlying dispute resolution? What are its different fields, ranging from litigation to arbitration and other forms of dispute settlements? What are the techniques applied? These issues relate to the main questions CPLJ wants to answer. CPLJ is a project of comparative law. Its basic ambition is to understand how procedural law and dispute resolution operate today in the different parts of the world. An additional basic assumption is that fundamental concepts and methods of dispute resolution are spreading around the globe and are influencing many jurisdictions. However, local habits, often denominated as cultural factors, may also modify or even block international trends from being adopted. The tension between the local and the global is a very important characteristic of the present procedural landscape. Yet, globalization entails that national systems must adapt to the growing competition in dispute resolution. Nevertheless, adaptation is always a matter of degree. Regionalism and economic integration are important frameworks and drivers in modern dispute resolution too. A major ambition of the project is to reveal major trends of contemporary dispute resolution. For the sake of illustration, I would like to highlight some of them. The quest for procedural fundamental rights, guaranteeing a fair and speedy trial. The quest for proportionality in civil litigation. The rise of collective litigation. The differentiation of dispute resolution caused by the advancement of arbitration, ADR, and consumer dispute resolution as alternatives to court proceedings. The impacts of digitalization on dispute resolution, private and public funding of litigation, the growing competition within and between national jurisdictions in dispute settlement. Recently, unfortunately, litigation has also become a means of judicial warfare in the hostile world of today. The biggest challenge of contemporary dispute resolution is the digitalization of the societies, of the economies, and the public administration. At this juncture, the digitalization of dispute resolution is part of a general development transforming the legal systems in general. Yet, the degree of the development is very much different in the diverse parts of the globe, and even in the different regions reviewed. In Africa, digitalization has not yet become a topic in large regions, whereas in Europe, China, and Singapore, it has become a general trend. Again, this does not entail any value judgment, as there are already some promising pilot projects in Africa, while some member states of the European Union are lagging considerably behind when it comes to digitalization. While I was very much looking forward when describing the ambition of our project, I would now like to look back for a moment. Is CPLJ the first project addressing comparative civil procedure? In this regard, one must immediately refer to the International Encyclopedia of Comparative Law, a still unfinished multi-volume project elaborated under the auspices of the International Association of Legal Science. There, a special volume, 16, edited by late Mauro Cappelletti, addresses civil procedure. This volume was closed when the last subchapters were published in 2010 and 2012. The elaboration of volume 16 lasted from 1973 to 2012, and it has become a very valuable and often quoted source of reference in comparative procedural law. However, some important developments could not be foreseen, such as the end of the Cold War, the rise of ADR and of collective redress, as well as the digitalization of dispute resolution. Other parts of the volume 16 have become outdated, like the chapter on arbitration in socialist countries, or I quote, on civil procedure in developing countries. This volume or this chapter has never been elaborated. In 2012, the still missing chapters disappeared from the table of contents. At present, there is no comparable treatise on comparative civil procedure, although the general treatise on comparative law usually also address procedural law. Today, the only available textbook on comparative civil procedure is edited by Chase and Hershkov. It is authored by scholars from different parts of the world who participated in Oscar's famous seminars on comparative civil procedure at NYU. But maybe an additional book is coming to be published. In addition, there is a strong tradition of comparative civil procedure in learned societies. The most topical in this regard is the International Association of Procedural Law. Since its foundation after World War II, it has been conducting comparative research in all areas of dispute resolution. The activities of the IAPL have been expanded over years, and its members have created a global network for collaboration and exchange in comparative procedural science. Here, comparison is primarily conducted from the perspective of dispute resolution, and the method applied is functionalism, although the methodology of comparative law has become a topic of recurrent debates. In my structure, I'm pressed a little bit too far. I have a part, and what I'm reading here to you shall be the general introduction to our project to be published on the webpage. I take up the 4 different research axes or fields of the project. As we have all been in the project, I don't believe that it's necessary to repeat them here, but we have here not only different parts or segments, but we also have some overarching ideas. And the overarching ideas is first proceed. We have different stages, and we have to look at the different stages of litigation of procedures. And another issue which is very important is, of course, the organization and authority of the courts. And we have to look at the old situation, and we have to look at the present times where courts are moving more and more online. And how are courts visible in the internet, in the cyber world? This is something which has been addressed in different segments of our project. And of course, the very challenging and important issue is the rule of law in civil procedure. Access to justice, the fair trial principle, the right to be heard, the right of defense. These are values which cannot be negotiated, and they are of fundamental importance, as well as the independence and impartiality of the courts. And finally, there is one topic which will always be a major topic. It is the questions, how much goes the divergence in comparative law? Do we have different legal families in procedural law? Maybe in some areas, other areas not. And to what extent do we see a convergence or a growing convergence in civil litigation? Just look at legal implants in some jurisdiction like collective litigation or ADR, which have grown over the years during the last decades. And these trends are certainly global. Also, the forms of collective litigation are quite diverse. So let me turn back to CPLJ and look back how this project has developed. Originally, CPLJ was conceived as a project of the former Max Planck Institute, and we already heard about it, for procedural law here in Luxembourg. The Luxembourgish Fonds National de la Recherche made the project possible by awarding an advance grant to me in 2019. And Mr. Ruby, I'm very happy that you are here. And I have to say, I felt very much supported during the more than 10 years I spent in Luxembourg, especially by the Fonds National de la Recherche. And we will see it's not only the grant, it was at several times that the FNR has supported this project. The initial idea was to use the resources, especially the library of the Institute, and to involve the staff of the Department for European and Comparative Procedural Law as much as possible into the project. In 2020, when the project started, 15 teams of 5 to 8 scholars from different jurisdictions were composed that addressed the different themes in their respective segments. In each team, a research fellow of the MPI should act as a liaison person to the Institute. 3 conferences at the Institute had been conceived to convene all participants. Already in May 2019, Enrique Vallines had joined the MPI and coordinated greatly the different teams. The IT department of the Institute developed a platform to facilitate online cooperation within the teams of the project. The Scientific Advisory Board met in October 2019 before the project started officially in spring 2020. Already in December 2020, more than 100 researchers out of 37 jurisdictions had joined the 15 working teams of CPLJ. And then we had a big change, and this was, of course, COVID-19. In spring 2020, the outbreak of the global pandemic changed the working environment dramatically. The opening conference, foreseen for spring 2021, could not take place on site in Luxembourg. Instead, the Institute organized a multitude of webinars where experts of comparative law and of related disciplines like economics, history, anthropology explained their methodological views to specific themes of comparative procedural law, as it has been originally foreseen in the segments 1 and 2 of the sub-project. These webinars started in December 2020. They took place every month, usually on Friday afternoon, with 2 lectures of 30 minutes, each followed by a discussion. For the participants of CPLJ, the webinars offered a first opportunity to start discussions among the members of the project. The 9 webinars on methodological and interdisciplinary themes continued until February 2022. They became a very important and successful part of our project. As already mentioned, the kick-off conference had equally to be transformed into an online conference. It took place in several webinars between February and March 2020. Each team presented an outline and first reflections regarding their part. The respective proposals were discussed by all participants. After the kick-off conference, the teams continued meeting and working online in their segments. The editors organized individual online meetings with the teams. On March 2023, you already heard it, the teams presented their findings and results, first findings and results, at the midterm conference here in Luxembourg. This conference was organized as an on-site event, and for many teams, it was the first opportunity to meet personally as a group. In the meantime, other teams had already met personally, either in Luxembourg or elsewhere. And again, the Fonds National de la Recherche de Luxembourg generously supported these meetings by funding an additional series of conferences at the MPI, where the teams presented and discussed their results with the researchers and guests of the Institute. This lecture series was organized as a hybrid event. The transfer of the MPI to the University of Luxembourg. Since the start of the project, the working atmosphere at the MPI deteriorated continuously primarily because of difficulties in the management of the administration of the institute. Soon, the institute became a topic of press articles as people were complaining about the internal situation. Finally, the Max Planck Society and the government of Luxembourg agreed on the transfer of the institute to the university by July 2026. This was a moment the two directors of the MPI decided to leave the institute. So I accepted a call to the University of Vienna, and I started in October last year, and Hélène Ruiz-Fabry returned to Sorbonne University in August 2023. At the end of September last year, the Max Planck Society was transferring an institute where many researchers were leaving. In January 2024, the institute, we have already heard it, was transformed into a University Center of European Law. The good news is that the excellent library will continue to exist and remains open for guest researchers. And I think this is also a very good news for all of us, as we all have been to the library and have used it, and we should continue doing it. And we should also support the new center, which will continue the work of the MPI. In these circumstances, CPLJ needed a quick solution. As I was no longer eligible as a PI in a project that had awarded by the FNR to me as a researcher based in Luxembourg, it was Séverine Ménétrie who kindly agreed to succeed as the PI in the project and to become a CPLJ co-editor. And I'm really grateful for your commitment, Séverine. With her help and her dedicated team, and I would like to especially mention Séverine Masik-Mariani. I think here we have also to applaud because she really has done amazing. It was possible to organize this final conference today and tomorrow. The ambition was to make the project a success, especially to publish and to disseminate the results via a special web page. Janos Weber designed this website, and in the final phase, the new Viennese team, led by Marcel Karl, who is sitting there and who will explain to you the web page in a moment, edited the manuscript sent by the teams to the co-editors, and so far 31 chapters have been uploaded to the web page, and I have to say I had not expected that the team would work so efficiently and so quickly. The team is here. I'm very grateful for your work done, and they will continue at least until the end of this year in uploading additional chapters, and then we have more than 100 chapters in the different segments. We will have even films, etc. So we will see where we will stand, and this is a very good moment. So I will not say anything about methodology because Margaret will do that. But what I would like to do is to say something about lessons we learn in the project. And I would like to address for a very short moment the future of the Institute, of the project of CPLJ 2. Let's look at the lessons we learned. What are the main takeaways from 5 years working in CPLJ? The first takeaway relates to the possibility of conducting a project with so many teams and researchers from different parts of the world. Here the result appears very positive. CPLJ demonstrates that a global scientific collaboration is possible. However, it needs a high degree of organization and of commitment. Organizing online meetings with participants in California, Hong Kong, and Luxembourg requires a lot from those team members who stay late at night or start extremely early in the morning. Distances were not an impediment to our collaboration. Time zones impacted a lot. Second, a global project of the size of CPLJ also requires a lot of preparation and interim communication. Here we all owe Enrique Vallines a lot of gratitude. He was able to address the different teams and their coordinators in a way that motivated and assisted all involved in the project. Furthermore, the coordinators played an excellent role in keeping the work within the teams ongoing. I cannot mention all of them, but a special thank goes to Rick Marcus, who made his team the fastest to hand in the manuscripts. Collaborative projects require time limits and discipline. Now, as we are approaching the end of the project, I'm happy to see that most teams have respected the time frame very thoroughly. Third, one of the most encouraging experiences of CPLJ was the online collaboration via Zoom and Teams. These platforms helped us to discuss and to exchange information online, especially during the difficult time of the pandemic. It was even possible to create a community online. This happened during the webinars and the kick-off conference. We met and discussed regularly. All cameras were switched on. I recall that after the webinars, in the Vicar building, we met with Enrique, Ramon, Nicole, and other research fellows to discuss the presentation and our debates. However, CPLJ also demonstrated the need of personal meetings and on-site conferences to physically experience a project with personal contacts. Nevertheless, we have learned in CPLJ that a good balance of virtual and real meetings makes a global project a success. CPLJ was by far not the only one that was conducted during COVID-19, but it certainly belonged to the most ambitious ones. As such, it opens up a perspective for future transnational and global research. The last takeaway relates to the publication of the results. There was a moment when the editors came to the conclusion that a publication as a compendium by a publisher house would not be an adequate solution for the project. The final publication would have been unaffordable for many researchers, and the individual authors would not have got any adequate access to the results of the whole project. Furthermore, a global project of this kind needs to be accessible for everyone, especially for those who cannot afford the expensive fees of Western publisher houses. Consequently, we opened for an open access publication that was professionally prepared by Janos Weber and by Marcel Karl. And Marcel, who had already been working with me in Luxembourg, organized the editorial process and the publication with a new Viennese team in a very efficient and professional way, supported by a team in Luxembourg and Margaret's team too. Thanks to you all, we can present the results of the project in a way we can all be proud of it. Let's look for a moment at the future of CPLJ. If CPLJ simply was a printed compendium, it would come to a preliminary end today, unless some additional editions would be published in the future. Online publications follow a different rhythm. Here the expectation might be that a permanent updating corresponds to the usual publication standards. However, this endeavor is certainly not feasible in a purely academic project. There is no doubt that CPLJ comes formally to an end after this conference. However, it might also be an option to continue the project by carefully updating its different parts and by completing those parts that are still missing, especially the part on arbitration. Continuing CPLJ is primarily a task for its editors. What I have learned from my fellow colleagues is a willingness and commitment to continue the project. Certainly not so intensively as we did it during the last months, but on a regular basis. We will certainly seek the support of the IAPL. This might permit us to update the project and to keep it vivid as a major achievement in comparative law and equally in procedural science. The final session of this conference shall address the future of CPLJ again, but I would like to invite you all to reflect about this issue during the next 2 days to come. I wish all of us a wonderful conference. Thank you.
How do I turn? Do I do enter? Just this. Okay, this. All right. Right. A little shorter than Burkhart, and then after like. Okay. It's so good to see all of you here, friends and colleagues. I'm going to talk a little bit about why comparative civil procedure is needed in the 21st century. And I want to start by reminding us that the beginning of the 21st century, we saw a lot of items that gave us concern. We saw the dawn of the war on terrorism in 2001. We saw economic woes with the Great Recession in 2009. And then we saw the global pandemic in 2020. And today, rather than globalization, as it was in the 20th century, the world are cleaving into geographic blocks. And according to some, what we're now seeing is a trend of deglobalization. And worse still, along with these divisive blocks, we may be seeing the rise of authoritarianism and the decline of democratic institutions. So with these changes, what is our role as a comparative? And with these changes, what is our role as civil proceduralists? So first, let us think a little bit about why comparative studies and comparative law. Well, clearly, more than ever, we need the knowledge of comparative law. Despite these political blocks, economies still remain global, transactions still cross borders, and communication and legal practice remain international in scope. So clearly, knowledge of other legal systems is necessary because it facilitates transactions. And as all of us comparatives know, knowledge of other legal systems help us to better understand ourselves. Our core assumptions are challenged by different ways of doing things and different choices made by different legal systems. We learn to reconsider and think a little bit deeper about what underlies our own systems when we understand others. And so we compare legal systems not just to find the most beautiful or the most exotic, but to better our own. Knowledge of different foreign legal systems is essential to understanding our own legal system. But I think more importantly, for all of us, comparative studies are needed today not only for the knowledge it generates, but for its perspective. With today's growing divisions, we have to open our minds and adopt differences. It is not only information and knowledge that comparative studies compiles, but it is a mindset that we all have here in this room. Comparative studies promotes a mindset that respects differences, a perspective that is sorely missing today, I think. So it is perhaps not a coincidence that comparative studies arose in the late 19th century and comparative civil procedure in the middle of the 20th century after the Second World War, periods of great instability. Clearly, comparative studies can be a good prevention against division and isolationism. Then, why civil procedure? Well, we know, we're in the field, that every society has disputes. And so there is also a need for dispute resolution, and foundational to resolving disputes are the rules delineating how to decide these disputes. And so the purpose of civil procedure is said to implement substantive law. But we, as civil proceduralists, know that civil procedure can be so much more. We are not just an adjunct to substantive law. Civil procedure rules have both universalist aspiration and political and cultural and social particularity. As C.J. Hampson observed so long ago, legal procedure is really a ritual of extreme social significance. And disputing and the process of how to decide these disputes really unveil the meaning participants attach going to law and courts. So legal procedure is not just a practical way of ensuring the enforcement on substantive law, but legal procedure reflects the collective sense of justice in society. And we have theories of justice embedded in civil procedure, ranging from notions of contractual justice to conciliatory justice to adjudicatory justice. Now, when the civil procedure resolution process is through the courts, our rules play an even more blatant political role. Often it is as much these rules and the process of resolution as the outcome itself that legitimizes the outcome. Acceptance of any judicial decision is an acceptance of the legitimacy of the state. And it solidifies the relationship between citizens and the state by providing this process of dispute resolution. And further, when the civil litigation involves public questions like environmental, labor, constitution, as you'll hear later in our presentations by, I think, Shenlin Huang from Taiwan, or Wilma Venta-Boscia, I think. Yeah. You will know that with those public subject matters, we are not simply asking for judicial resolution of individual disputes, but we are also seeking to be participants in the process of shaping community norms through litigation and in challenging inequality between social groups and between citizens and the state. And so, again, civil procedure is not simply the rules to enforce substantive rights. They are not simply an adjunct to substantive rights. And in fact, as we've learned in many countries, civil procedure can also be a source of fundamental rights itself. It is a fundamental right to be heard, to be given due notice, and to be given human dignity, to be treated with respect in the dispute resolution process. And we will hear a little bit about that in later presentations in access to justice as a human rights, recognized in many international instruments, as well as by national constitutional court. I mean, Severin Menetre and Tanya Tomei will speak to us a little bit about how procedure itself can be a constitutional and human right. And so, with such importance, almost all legal systems have civil procedural rules and govern how a dispute is to be litigated and resolved. And reflecting what role civil procedure may play in that society, civil procedure may be broad or narrow in deciding who can sue, who can be sued, and where the suit can be brought. And the legal philosopher Ronald Dworkin said it well at the beginning of his book, Principle, Policy, and Procedure. Nothing is of more immediate importance to a lawyer than the rules that govern his own strategies and maneuvers, and nothing is more productive of deep and philosophical puzzles in the question of what those rules should be. Okay, so when we marry these two topics together, what do we have? The question then is now, where are we in the state of comparative civil procedure? And I need not remind this very august and expert group of experienced legal scholars that comparative civil procedure is a relatively new discipline. We have legal scholars like Alan sitting there, Uzalik, and let's see, who else? Eduardo Ortega, who reminds us that civil procedure and civil comparative law is a relatively young field. And even the prestigious International Association of Procedural Law was only established as recently as 1950. So the early years of the discipline, we saw debates as to what constitutes comparative civil procedure. There were long debates about the nature of the methodology. Is it functionalism that's important for comparison, or should the focus be more on legal history? What about the study of legal transplantation? What should be compared? Now, without necessarily resolving these debates, comparative civil procedure have forged forward. Today, we do have an impressive stock of treatises, case books, known to every member of the Guild. Indeed, comparative law have moved beyond simply methodology and has become a discipline with its own substantial body of materials. It is a field of substantive knowledge covering different subject areas, including civil procedure and enormous geographic areas, although I think Africa, Latin America are still under study. Black letter rule comparisons still dominate, but they are now rich contextual studies of historical development, social context, and law with cultural characteristics. There have been efforts to map legal systems into legal families, legal origin, traditional culture, as well as coordinated principles to harmonize law, whether that is the ALI, UNIDROIT principles of transnational procedure, or the ELI UNIDROIT model rules of European procedure, or the EU's own efforts to harmonize member countries' civil procedure. And we now debate about the interaction between legal system. Is it borrowing or is it exporting? Is it converging, divergent? Do we see legal transplantation, or is it a matter of legal translation? So today, we even have critiques of comparative law. That's a real sign of a true discipline when there are critiques of the discipline. We see critiques that says that that ranges from criticizing comparative law as being mere descriptions and comparative civil procedure as excessively rule-oriented, and to an argument that there's a lack of a coherent canon within the discipline. The field has also been criticized for its persistent Eurocentralism and a lack of attention to other parts of the world and international regimes. And finally, comparative law has been criticized for all those harmonization projects, because the idea is that we should recognize and celebrate the diversity in foreign legal systems and cultures. Yes, it is the final CPLJ conference. And so, specific to civil procedure, challengers have argued that procedural law may be so interconnected to a legal system that we really can't separate one aspect to do comparisons with the other. And so you have the Anglo-German comparatives Otto complaint that comparative law has far greater utility in substantive law than the law of process. And I certainly disagree with that. And finally, postmodern comparativists, in embracing legal pluralism, even question whether linguistic and cultural barriers can ever be overcome. And we could see obstacles in our own work in trying to overcome some of these linguistic and cultural barriers as we were working on this project. So what must more be done? What are we to do with all this information? The comparative Matthias Reimann correctly states the most urgent agenda for comparative law today is to integrate the accumulated information into whole, which is more than the sum of its parts. And we have seen some major technological data, such as the projects, such as the Les Mundi or the Rule of Law Index by the World Justice Project, and that seeks to make sense of all the data by measurements and rankings. But as Christopher Kahn, I don't know if he's here today, so rightly warns us, these rankings and calibrations cannot substitute for deep understanding of comparative studies, of complexity, of the real world aspects of legal systems. What should be measured cannot be expressed in numbers. And so meeting the challenge posed by comparative civil procedure requires us to consider real world functional equivalents and their context. And the CPLJ project seeks to meet just such an agenda. I want to call your attention to the title, Comparative Procedural Law on Justice. The choice of the word justice added in there is intentional. It is the promise of accuracy, fairness, access, and efficiency that drive every modern system of civil justice. But we only want these features if the decisions are fair. We care about procedure, but only if it can secure justice. And rather than just collecting numbers and data about individual legal system, CPLJ matched scholars from different regions, and which actually, as I recall, took quite a bit of time of trying to ensure there are sufficient representation at every segment. And now today, CPLJ has a diversity of 37 jurisdictions representing from all 5 continents. And of course, recognizing that all civil justice systems do share similar tasks. And of course, as we know from Roscoe Pound, much, if all, not all depends on what is compared and how it is compared. So the determination of what we're going to put these segments in terms of subject matter took quite a bit of time. But the organization of CPLJ focused on core functions of civil litigation. So the general course of litigation is roughly follow. We have a plaintiff commences action with a complaint, and we focus on varying degrees of standing, varying degrees of sufficiency of the complaint. File in appropriate jurisdiction. So now all the different jurisdictions can discuss the varying degrees of assertions of state power in determining jurisdiction. They're filed in notice given to the defendant and reviewed by the judge. And then the various jurisdictions in your segments review the different varieties or degrees of review. Evidence is then unearthed. And again, we look in varying degrees in different jurisdictions of how the responsibility is allocated between litigants and judges in gathering information. And then we focus on the impartial judge, and segments focus on different degrees of selection and training. And finally, courts are expected to base their decision by applying law to fact. And again, these different jurisdictions have varying degrees of responsibility. Who is defying the law? Bring it to the attention of the judge, right? And with some finality of the judgment. Again, we see varying degrees of enforcement and preclusion. So these varying degrees really, it's like a spectrum, lie with how responsibilities are allocated. Who gets to do what and the role that civil litigation serves? Is civil litigation primarily to resolve individual disputes, or is it an assertion of rights? Is it to change public norms, or is it to do all three? And these different goals of civil litigation and the different political polity of legal systems will be reflected in these varying differences and degrees of assertions in the various topics. So CPLJ, again, also focus on special matters that warrant exception to transnational, that warrant exceptions to the trans-substantive nature of civil procedure. And CPLJ also recognizes technology, challenges of technology. So now we have an abundance of data, right? This group as a collective has produced an unprecedented quantities of information. But as Burkhard just mentioned, this is really the beginning, not the end. This body of data and its open access data can serve as a foundation for additional inquiry for all of us, for the development of additional questions and theories, and for the further integration of the data, and for the contribution to a larger theme. And in short, as an open access project, the data is available for us to continue to build on each other's works. There are still micro questions to be asked. Again, how are some countries restoring power disparities between actors in civil litigation, litigants, judges, lawyers, or there are micro comparisons that we can still pursue. How are different branches of government, how does the court sit in terms of different branches of government by comparison to different countries? And what is the relationship between law and politics? These are all questions that we can further test the hypothesis in the data we've collected. And on a theoretical level, we can also ask if civil procedure stands as a right on its own, because we know an outcome-based theory behind civil procedural rules would justify reforms based purely on utilitarian principles. But if we all agree that there are certain human rights principles in civil procedure, then we would have to ask ourselves, when could those rights be compromised to pursue and maximize efficiency and utility? So I don't know. I think I lost my,
Now you are in my presentation.
yeah. Well, in any event, oh, okay. I think we got it now.
Great.
Okay, so future tasks, as I said. What civil procedure presents is an ideal special case for comparative studies. It combines the universal with the cultural, is driven by universal norms of efficiency, but tied to specific legal actors and institutions and history, is part and parcel of nation building, but faces pressure from globalization and transnational conflicts. This project will expand the discipline of comparative law, challenge our preconceptions, instill additional questions for exploration. CPLJ, this project that you are all involved with, will unearth, I think, the future of civil procedure. So thank you so much. Okay. So to continue on with this idea that this is an open access project and that this is a final conference, but really the beginning of the project as much as its ending, I'm going to turn this over to Marcel Carr to introduce you to the website that we've put up. Marcel, who is with the University of Vienna, who's been instrumental in setting this all up.
Okay. So, thank you so much, Margaret, for the introduction, and thank you all very much. I don't really need the computer because I'm not the one in charge now. It is Jano Schar, but apparently Google is working on a new picture right now, and I would like to start by thanking my team in Vienna, and I need your assistance on that because whenever I told them this is particularly good work and you're working more than I can expect from a PhD student or student assistant, they wouldn't believe me. So please join me in applauding Jelena Gwoszczyn, Igor Schindelmeister, and Julia Helminger. So can we see? Oh, we can see Luika here. Okay, this is very nice. Maybe it's also possible at some point to see Jano Schar, who is the web designer who was responsible for the website. I assume you all used the link. Maybe some of you tried to Google it and it didn't work because we blocked it. Yes, because we promised that we would only make the website publicly available as of today. And as of today, Janusz will show it. We can access it. We just chose a random topic that maybe one person in the room finds himself connected to. So as Burkhard has said, we have 31 chapters uploaded today, and we will continue to upload in the weeks and in the months to come. And if we receive all those chapters in time or at all that have not been submitted or that we return to you, we hope that first round is finished sometime in October or so, and then we will look at the details and all the errors that we made until the end of the year. If you will not have received anything from us in 2 weeks' time, but you submitted something, please write me an email because then we overlooked it. If we haven't heard back from you, at some point I will get back to you and ask you what the status quo is. So if we, Janusz, can you go to the home? Yes. So you know that the website is divided into 4 blocks. We have the about section, the publication, which is obviously the most important, the news, and the webinars. Okay, maybe I have an echo produced. I don't know. The IT will fix it somehow. And I would like to go through with you very quickly. If you click on the about section, maybe some of you have been able to click on about itself. We fixed that error because only if you clicked on about you could see something which was more than 2 lines about IAPL. The About section gives an overview of how the project developed, who contributed, and how the content is divided. So this is, I think, a very good, if you look at the parts, it's a very good short overview of the project, because the overview of the publication itself eventually is going to be rather long. In the section News, you will have seen the announcement of the final conference, which was so far only internal, and we will put anything in the future development of the project on that section. We will see how we distribute it to you and to other people. Maybe it is not useful to create our own newsletter, but just to use social media as they already exist. And we very much also depend on your support also when it comes to distributing the link to the website. Now, under the webinars, we made available 2 CPLJ webinars already because we received the consent of the presentators to it, and we emailed more to get more webinars to put online. We will also put parts of the conference that we believe are useful to the public on the website, and anything else that is in form of a video. And then we come to the core of the project, that is obviously the publication, and we will not look at the very core yet, but start with the contributors. You might have seen a list that was not very well sorted. We have sorted this problem out. If we look at, for example, Stefan Huber, we can see some author information, then also the contributions if an author contributed to more than one chapter. And then finally, there is the overview of all the published chapters, of which we expect to have around 100 at the end. And maybe we need to change the overview because it will get messy if the webpage is too long there already. And if we there take the chapter by Geneviève Sommier as an example, you can see that the header we created, we put in the date of publication. Janusz, you need to scroll down a bit for me, please. The editors, then we have an ISBN where we wrote to be confirmed. Once parts are completely finished, we will see whether we can organize a print on demand, which will then be accessible somehow through the ISBN. We are in contact with the publisher for this yet, but since I believe there is not a single final part yet, this was not urgent enough for us to deal with it at the moment. And then if you look at the license, this is one of the open access licenses, and it simply means that it is open access for non-commercial use. Okay, and Janusz even created a new link to that, so you can see the details of that as well. And now we go to the more technical details of the website, and this is where I will hand over to Janusz to explain it, because he dealt with that. I told him my wishes, but he knows better. Thank you, Janusz.
Yeah, thanks a lot. Yeah, there's a few accessibility features, if you will, on the website that make this quite interesting compared to just having the PDF version. So as you would expect, you can just download the PDF version of an article on this page, and it will either, depending on your browser, open a new window, or you will get a download, and this is the final version that you will know ready to be printed or to be worked with as you do. But the website provides some extra accessibility features beyond just having the PDF function. One of them is that for every publication, we have automatically generated citation suggestions. And there's 2 of those. One is the full-length citation suggestion with the authors and the name of the CPLJ, the parts, and a link. But we also have a short citation suggestion depending on your citation style. And we have a very cool auto citation function on this page for which you can choose which style you prefer. And how this works, that if you, in the actual text document, select a piece of text, for example, this piece, you will get this pop-up telling you that the text that has been selected has been copied. And you can just paste that into wherever you're working on your current manuscript, and it will automatically paste in quotation marks the text that you selected, excluding any footmarks. So it will clean it up, footnote, sorry, it will clean up for you and will automatically add the citation based on the style that you suggested. So if you select the short citation style here, and we do the same thing, and you copy, so you just select the text on the website, you switch over to your editor, you will get now the short citation suggestion. So this will make it a lot easier for you to quickly copy segments with the right citation. The other accessibility feature we have in our articles are in the footnotes. So you can, if you hover over footnotes, see a preview of the reference. And if you click on the footnote, it will automatically jump to the right footnote in the appendix. So you can explore that and copy that. By clicking on the reference here, you will jump back up to the text, so you can continue reading where you were. So it's a really quick function of checking references without stopping you from exploring and reading an article. Every chapter also has these two navigation buttons, which will automatically bring you to the previous and the next chapter. So if you're reading, for example, through a part and you're looking for a certain theme, you can just quickly jump through a few chapters with these buttons until you find what you're looking for. In the sidebar, we have a few extra blocks that give you some additional features to explore CPLJ. One is the search function. I want to come back in the very end. Then we have tags, which the team is currently working on to produce for the different articles. They are meant to, kind of, based on a content level, bring together different publications. So it's easier to find kind of relevant, connected publications and explore them like that. We have a table of contents, which is because they can range in length by default collapsed. So you will notice this little caret that you can click to collapse or unfold the table of contents. And this table of contents will stick to the side of your screen when you're scrolling around. So you can always jump to a section and explore the document like that by just clicking on the links in the table of contents. The other block, which now wasn't visible anymore because I have quite a zoom on to show you this website, but there's also always a journal structure on the side of your screen, where again the different parts are collapsible, so you can open them up by clicking on them to find the different chapters in a part and quickly jump to them if you want. Lastly, as I mentioned, we have the search function, which at the moment is still relatively rudimentary, but it's still in development, which is a search function that works within the entire publication of CPLJ. So if you, for example, search for Germany, you will find all mentions of the term Germany on all the different publications that we have online at the moment. And it will give you for every publication also the 5 first matches of that search term within a document. And this is a new function as of this morning. They are now also clickable, and you can automatically jump to the location in the document where the term has been mentioned, and it will highlight the correct paragraph for you. Oh yeah, that's, by the way, if you copy a bit of text, it will automatically also copy this paragraph number, as you will have seen here. So you don't even need to worry about copying those. It will automatically detect that for you. This is also a feature that's currently still a bit in the works, so it will fail if you select a range of paragraphs, but that's something that I hope to fix in the course of today or tomorrow. So there's a few of these minor things still ongoing. But otherwise, I think this is already really useful. And we're happy for any feedback now, actually, I think. Right, Marcel?
Yes. Yes. You are through. Okay, so because this is the final conference of a project that is almost finished, we are super happy for any feedback that you can give, and Margaret Wu is actually going to take over.
No.
Here.
I thought that we might solicit a little bit of discussion about this website. I have to say, sitting there, and I've seen this website 2-3 times now, I'm even more excited because it really looks very user-friendly. And I hope this will motivate all of us to complete our chapters in an even more final version, and then to go back and use the website. And then thirdly, to spread news about this website, because I just think the information in there is fantastic, and I'm so glad we did not go with a traditional publisher who cannot do what Josh just did. But we should solicit and get your comments about how we can improve this. Any thoughts? Yes, Genevieve.
Thank you. And thank you for having put my chapter up, because I raised some questions, and it's a question we had a discussion about. So the title of the chapter is Access to Justice, and I was saying, well, don't you want it to say in cross-border disputes, because there's another whole part on access to justice. And my response was no, because the reference will include that this is in the part on international and cross-border dimensions. But now I see that, in fact, the way that you've set up the citations, it only says the number of the part and not the name of it. So that would lead me to say, oh, well, I think that, I want to go back and say, yes, maybe add to the title.
Okay.
So I'm wondering, because I know this citation is already quite long, got a lot of editors, but very often when you have chapters in parts, or in books, right, you have the title of the book. So I don't know if that's something you've thought about. Is it just going to make it too long? Because otherwise, when people search online, they'll just get these responses, and it might, just not be as quick as otherwise. I find it's amazing the navigation within the site.
Yeah.
But when people are doing research online and then they get the results from the site, that's going to be as precise as it could be. So sorry, that's sort of two different questions. I don't know Marcel or Jan,
Yeah, so the question really is two layers, one within the project and then one without, is what you're concerned. And they're primarily having to do with how the title, whether or not it's searchable. And so there's a technical part of it I might turn over to Janesh to answer. And then there's also, I think we as all authors, we might, just to brainstorm, we might want to start thinking about what keywords we want. And we might want to add a keyword listing for each of the chapter. That would enable actually better search functions outside the project as well as inside. But Janesh, do you have a thought?
Yeah, on the technical side, there's a few factors that play into this. And you saw in the beginning, we searched for private funding CPLJ. If you only look for private funding at the moment, this site wouldn't be found because it's just not relevant enough yet for a very general term, right? So the same thing would happen, I guess, with other shorter chapter names. But there are two factors that would, over time, kind of work to consolidate this, which is once this site is being used more often and it's being linked in other projects and in other publications, it will gain more relevance in Google searches, and automatically our sites will rise to the top in Google searches, even if the titles are shorter. The other bit is, as you also just mentioned, there is a lot of other content on this page that Google will keep track of. So even though the title is short, we have, for example, the title of a part on a page as well. And we have this space to add these metadata tags. So this information is, even though it's not kind of shown on the search result pages, available to Google and will be respected when visitors are looking for those terms. So in terms of kind of searching for content, there are ways to make this available to people looking for certain terms without having to have the full, for example, part name in the reference. But that said, I don't know your preferences in citation styles and kind of reference setup. So this discussion, I think, is more on your court, whether you, for example, want the title of a part in the long citation or not. That's not really something I can speak to, I think.
Can we add within the website a list of keywords for each chapter, such that those words will trigger researchers searching within the document as well as outside?
Yes.
Is that possible?
A part of it are these tags. So we can already start using these tags as additional information to enrich the information that Google has on what is in this article. But there's also, even on a more technical level, fields for metadata where we could add those kind of tags or other or similar tags, just to be visible to search engines, to know what information is available on this page. So that's definitely possible, yes.
But Genevieve, maybe we can come back and talk some more, because that's actually a great question about how to make this website more accurate and searchable for, because we all want to use. Alan.
It's just a low-level tech question, and this is whether hyperlinks in the text are going to be linking to the web pages to which they direct, and whether the internal cross-references will be such that, for instance, when you write see below, and you put the paragraph, that you will be able to click on that paragraph and then get to that place, and whether there is some interlinking. For instance, I write on a particular topic, and then I say Genevieve has written on that in, and then there is a place in the other text, and you just click on that and you get to this part. It would probably imply a little bit more low-level work by the editorial team to hyperlink everything, but that would be very useful, and also warranty publishing in this this electronic form.
Okay, I think I can reply to that. So hyperlinks you put in, we tried out many, most of them worked, some didn't. Either we searched for them or we emailed you and told you this hyperlink is not working. We upload it still, please provide it as soon as you want. If you put something in, it works on the website, it works on the PDF. If you have cross-references within your own document, I know that in the PDF version, if you provided proper cross-references, as in not manual but linked ones, they will work. Janos, I don't know about the HTML version. Do you know about the HTML version?
I haven't tested them yet. I need to have a look at it, but technically it's possible because all paragraphs are ID'd by their number, so we can jump to the right paragraph. We just need to make sure that the links are set up properly.
Yes, and this is where we encounter a big problem because we need to set up every single cross-reference. Especially, I think it is very difficult to make it between the chapters. Within a chapter, I think we can optimize it. Between the chapters, we might be confronted with a problem, and we have that in mind. Let us see how far we are with the main, how fast we are with the main work, and whether then we have time to add to that. We are aware that there is an added value, but we have the drawn structure on the right side. You can click on it, you scroll a little bit down. Yes, you're not as fast as you could be. We try to use some AI to create the text. It worked quite well, but our impression so far is the work that is required for this is too diligent, and AI is not diligent enough yet to assist us there properly.
Yes.
Yeah. You tried the two websites, the current one and the previous CPLJ website. Because when I removed CPLJ, the previous website was over, and the new website was far, far below some recreation center.
You mean with the new website, the MPI CPLJ subpage?
So,
Janos, can you just Google it so we can see
Yeah.
it? Okay.
Yeah.
so on the top is the CPLJ.
Oh, yes, okay. Yes, I see. We will solve this problem, or you will solve this problem by creating links, telling your colleagues about CPLJ, Googling it yourself and clicking on that link.
Well, can we just eliminate the previous website or incorporate the previous one to the new one? Because the top website shown on the top just gives us some wrong information.
You mean the Max Planck Institute website?
Yeah.
With CPLJ project.
https://MPI.
Okay. Yes. Okay. Thank you very much. We will have to look into it. How we do it.
Yeah.
This is a very good suggestion.
Yeah.
The organization doesn't even exist. other thoughts, comments?
Maybe what you did not say is we also have a function to count the clicks and the downloads.
Yes, yes, we do. Janos, maybe you wanna say a word about it.
Yeah, trying to not get too technical, but this website is a bit different than traditional websites. So traditionally, you would have a database where you store all of your articles, and then every time somebody opens the page, you look up in your database what's the article and you load it up, which takes a lot of time and it makes it a bit awkward to search because you always need to first load the database, then look through the documents, and then search in it. So this website is built with a new technology, which basically builds a static website every time it's updated. So every page basically is ready for visitors to open. So the advantage of that is it's really fast and it's really easy to search, and it's really good also for Google to know exactly what content is on a page because it doesn't need to be loaded. The downside of that is that we don't have this function where every time somebody opens a page, automatically we can see, hey, somebody is reading this article and we can count it. So we have a kind of a new way of tracking views of this page and also of downloads, which is basically through a hidden pixel. So every time somebody opens this page or clicks on a download button, it requests a hidden pixel from a service that we subscribe to, which will track that for us. So we can basically see how often is this pixel requested, and that will count for us how often a certain publication has been opened or how often a certain download button has been clicked. And we can track that. And I will look into if there's a way to maybe get those numbers back on the page. And otherwise, we will probably do some kind of periodic reports on those statistics if we can't get them to automatically kind of feed back into the site.
Yes.
I believe you said that it is possible, it will be possible for the authors of each chapter to update it now that we know every chapter and every part. So that should have an impact on the date of the publication and the different versions of one chapter. How do you plan to deal with that?
Okay, I mean, if in August, Genevieve decides to delete 3 typos, what we will do is we will change the date of publication to August, and that will be it. If next year in August she wants to publish a new version, next year in July we will think about how we give access to the former version. I mean, to put on the new version is not a problem at all. Yes. We don't even need Janos for that. We can do it ourselves. But once we have kind of a second edition, like a second proper edition, I'm very sure that we will find a way just to have another button to which on which you can click and say, look at version of July 2024. Okay. I think this is all the concern you had, right? Yes.
Maybe also a small question, like, do we have a joint policy on using other open access platforms like SSRN, academia.edu? Do you encourage us to do this, or do you prefer, or are we completely free to choose where we put our texts else?
I think we'll have to have an internal discussion about this. But my own position is, if you want to post at SSRN, so long as you mention that footnote that this is in fact the primary home for that piece, then that may be fine. But we might have to have greater conversation.
I mean, the best way for the CPLJ website would be just publish the link. Link it wherever else you want to put it.
Yeah.
And make sure people go there.
Yeah. That's
so
a great
we get the counts, we get the overview of how it is accessed.
Yeah.
You can make sure by that it stays centralized, and if you publish it in 3 other sources as well, or mention it there.
That would be great, now that I think about it. Yeah.
Then if you update anything, you're going to have to update it 3 times.
Yeah. Another question, yeah.
Another question, just out of curiosity, if it's an open access, then will it be used in machine learning by OpenAI or Claude?
Used by what?
LLM for large language model,
Uh,
like AI.
Janos, what do you think?
Yes.
In principle, yes. In principle, if it's available on the web, they will scrape it, and if there's no kind of copyright concerns, and maybe sometimes if they will use it. There are ways to set kind of like technical flags on the website to prevent bots from crawling it. That might stop them, but it might also not, and it might also interfere with disappearing on search sites. So there's this kind of trade-off that if you try to block bots from parsing this and using this in their training data, you might also lose access to some search functionality. So yeah, it's very likely that this might be used in the next web scrape and then might come back in a few generations in those models.
You never have thought of that.
It happens.
It happens, I guess, yeah, you're right. That's why it's good to have you raise these questions. Is that it? Well, maybe we should move on then to the next portion. Yeah.
You already made it, but I have to say we have to be very grateful to these two men who really took it up. I was very often asked during the last 5 years, how will the publication mature? What will be the outcome? We don't know. And now we can come back to you and show this web page, which is a wonderful one and will be very helpful for our own research. So thanks again. This was a wonderful moment of the program.
So I think we're now moving over to the next portion of the program, which is to have the different segments present their preliminary / final conclusions. So the first, I think, Alan, who's presenting, by the way, you got that, I'm not sure, and Severin, yeah. I feel like we don't need to do introductions. You all both know. Yeah. Do you want to stand at the podium? You have a presentation, PowerPoint? Okay. Okay, then why don't you guys?
Okay, very good.
I'll come back up when you're done, please.
I will be best.
Yeah, there is on the, it's on the. You just answered. You just, are you on the clicker?
So instead, the program.
The clicker. The clicker, la commande.
So as the program indicates, what we're going to hear from is from Alan and Eduardo Ortega to talk about the organization of civil justice system, what their teams have been looking at.
You're not going to stand up there.
The computer helps the same.
Yeah, I had to say something.
You can see it. Or you can just go back to the Yes. Would it be better to stand up or see the But maybe to stand up. It's better to sleep. You can use either this, or you can use that arrows.
This one.
Yeah. But I'm right.
Okay. Well, good afternoon to everybody. It's really a pleasure to be here. After a long time, this adventure started many years ago, but a little more, okay. But time in this kind of enterprise is really time consuming. The first thing that I want to highlight is the the academic and personal involvement of the team. It was really a great pleasure to work with John, Julien, Alan, Hermes, and Inga during these years. And John. And John, I mentioned him. It will not be possible to go into the details of the courts and the concept of court and the different issues that deal with in our part or in our segment. This is the table of contents that we already prepared and we are reviewing. For a long time, I continue to think that this is a sort of continuation of volume 16 of the encyclopedia. And this enterprise started at the middle of the 80s, and the last piece of work delivered was in 2008 by Tarufo, the research on evidence. And when we started with this, one of the idea that we discussed was which will be the outcome of our generation in terms of civil procedure. How can we improve what they did in this volume as a main work? And because of that, probably we started thinking on how our segment is in connection what Clark wrote in that volume, in volume 16. He delivered his work in 2002. Nevertheless, the process started very far from this period. And we discussed with the editors about the applicability or the usefulness of this piece of work. And they answered to us the different changes and the different approach that we are discussing. For example, Clark started with lawyers, and we not focus too much on lawyers. But why this? Because the project, when started, was mainly with their own culture, trying to be comparative with others. It's clear in this chapter that Clark talks about his culture and used the comparison method, but without outcome the vision of belonging to certain culture. And nowadays, the possibility of interact with other cultures improve a lot. Other piece of work, who was the editor of that encyclopedia too, was Capelletti. And one of his extraordinary works, I must say one of the relevant one, was, and related to our chapter, was Who Watched the Watchman? And this was delivered in a Congress of Comparative Law in 1982. I reviewed the work, and it's really different, totally different our reality than the reality that Capelletti worked with. Let's say that in that moment, it was the Soviet Union as an entity, which is no more. And the discussion of that period were very different than the one that are for now. But during these years, obviously one of the difficult things was to outcome the COVID-19 and the effects of the COVID-19. And during the COVID-19, we continue working. And the project gives us the possibility of interact through webinars, which was, at least for me, very important. I remember, and it's now in the web page, the webinar in which Ralph Michaels talked about decolonization. a issue that was not clarified in this volume, an issue of our area, the notion of decolonization is not more common law and civil law, is much more broader than this notion. And we discussed deeply this notion. And obviously, this cause and effect in our work, because there are not only state courts, are more than a state court. For example, indigenous jurisdictions that plays a role in society. And when you compare, you have not only to see the universal side of the situation, you also need to pay attention to the epistemic communities. And also there was a conference in another webinars by Horaisha Muir-Watts, in which he works with the notion of epistemic community and the impact in the whole, and the interaction with the states and supranational entities. We make reference to regions, particularly, and interaction in different cultures, and the advances in different cultures. And we have the possibility to have persons for different parts of the world with different visions that can interact. Also, we pay, related to that, we pay a lot of attention of what supranational entities do, like supranational courts, for example. Not only the European court, obviously, is the more developed region, but the coordination between the European Court of Justice, the Luxembourg Court, and the Inter-American Court, the African Court, give us certain lines of reason that are very useful. As Margaret mentioned, we have a lot of indicators. What? Sorry. Time. No, I'm running. I pretend not to understand, but I understood you for the beginning. But the interesting thing is the attention that the international community pays to this sort of analysis. Not only indicators like just as World Justice Project. For example, Freedom House, DIM Institute, which also analyzed the rule of law. But we used to analyze the value involved in the role of courts. And also I mentioned the issue of decolonization, but not only in the sense of indigenous people. There is a huge problem about the law, which is the Muslim law and the Sharia, which also we have to pay attention because it's civil litigation also in that sense. This is the topics that we deal with, and Alan, if you want, you can go to the court place. The floor is yours.
Good. Yes, well, I'm here just in a pars pro toto role because we would like to show you how we work and what we produced. And the first chapter, which was assigned to me, was the chapter on the meaning of a court. And you can see that this is a little bit different from the original encyclopedia. As Eduardo said, it started with lawyers, and we actually have very little on lawyers in our part. Maybe over time we'll get to that topic again. But we can note that originally in the encyclopedia, there was something about judiciary, but it was taken as a, so to say, a straightforward and simple topic. But now 20 years later, we actually have something new. As we have heard, there are some unexpected developments that could not have been foreseen at that time. And we also singled out digitization in the first place, financial crisis, perhaps in the second place, which caused also a huge wave of privatization. And finally, the pandemic, which also assisted a certain transformation of justice systems. And therefore, it seemed to justify to emphasize the fundamental concept of any civil justice system, which is the concept of a court. And then, well, in the chapter which was assigned to me, and we had a lot of collaborative discussions, we have identified, I have it identified in my piece, 7 layers of meaning, 7 distinct aspects of the notion of the court. And, well, in the paper, which is now close to finish, so it only needs a little bit of very final nuancing and also a discussion in the group, because we really had a rather collaborative approach to all of the topics. We would like to actually see each other's papers and well, like a exclusive information. We do have all of our papers, but we haven't been we didn't want to share them as yet, but they're going to come and hopefully come soon. So I have already spoken at the our interim intermediate conference of the CPLJ, so you maybe know these 7 layers. It is layers of court being a place or a forum, court being a community, a cohort, or court, the state power, imperium, court as a body for adjudication, in Latin judex or tribunal, court as legal authority, auctoritas, court as public service, and finally court as an institution which brings equilibrium in society, which is associated to the notions of justitia, equitas, and the values of access to justice and fair proceedings. And I will skip now detailed explanations because, well, again, we don't have time, and it's also something that I wouldn't like to repeat. I would only like to focus on the trends which are nowadays impacting these 7 layers of meanings, and which are identified then in the chapter which I produced. And let me start with the court as a place, as a forum. And in many languages, actually most languages, the word court denotes a space, a single and identifiable area in which court activity is organized. Once it was a square, then rooms or a court building. But what we see now, due to all of these changes, is that the spatial component of the notion of court is evaporating. First of all, well, as lifestyle changes, well, we have the improved transportation facilities, and of course also improved communication possibilities, which all lead many jurisdictions to reducing the number of courts as organizational units. In a parallel development, the court also becomes more and more virtual entity that has multiple seats, comprises several buildings, different places, various other contact points. So the virtualization of the notion of court is one of the things that has happened even before digitization. We can mention, for instance, Netherlands that has 11 courts for 17 million inhabitants, but courts with multiple seats, and very different from what was once upon a time considered to be a court. But then with digitization, the courts are further losing their spatial determination, and they are becoming less a physical space and more virtual space. And of course, we can all say that this can be a positive development as digitization enables remote access, but it also produces a certain alienation and potentially jeopardizes crucial court function. So yes, virtual digital courts, fully digital virtual courts, they are emerging, but it's one of the things to be flagged, and the limits of this development should be further explored. The second element, the court as a community. The notion of a court always implied that courts, while delivering justice, express the views which are not individual but reflect the views and value judgments of the community. And in recent times, some crucial elements of this notion are also being put into question. Actually, the process has been ongoing for some time, but one of the interesting developments is that lay participation, which should be one of the main democratic elements in the civil justice system, is, as we can see, disappearing from at least some civil justice system, and it's many countries it is almost extinct. The second element where this element of community is being questioned is the principle of collegiality. It is important to note that, well, the fact of collegiate adjudication is of vital importance for not having an individual decision, but a collective decision. And in the context of the use of AI, it maybe remains the only element in the court activities which is almost impossible to be replaced by any form of artificial intelligence or digital algorithm. However, we can also see that the principle of collegiality in many jurisdictions has been for the purpose of enhancing the speed or efficiency put into question. The third element, court as an organ of the state power, the imperium element. It is a very classical element, almost self-understood, but now it is also being questioned because the domain in which public dispute resolution dominates is at present shrinking. It is facing pressure from two ends, from both the high end and the low end. At the high end, we see an increasing number of complex international commercial disputes which are being steered to private channels such as arbitration and other adjudicative bodies, dispute resolution board, etc. And at the low end, small claims and consumer disputes are increasingly handled by private and administrative sectors with a trend towards outsourcing of many judicial functions. The fourth element, the element of the court as an adjudicator. The processes affecting this key layer, and this is the layer that the courts adjudicate disputes and issue judgments based on facts and law, is also evolving. The courts are still perceived as adjudicators, but there is a lot of space for mixture between administration and adjudication nowadays in the courts. Even the perception of courts as organization puts into question what is a court. Is it an institutional or is it a panel that adjudicates? And I must say pretty well proudly that today at 10 o'clock the CJEU published decisions in cases Han Invest and KHL Medveščak, Croatian cases, which have, to my surprise, actually evaluated this element of what is a court and decided that any internal element in the court, even the administrative ones, the referendaires in the court or the court sessions, if they have an impact onto litigation, need to be subject to all of the guarantees of judicial independence and judicial status. However, we see that as a problematic element, and also we can see when it comes to adjudication that empirically the number of cases which end up with adjudication is decreasing. The phenomenon of vanishing trials and also, well, in Germany, the low tide of litigation is something that happens. And very briefly, the court as legal authority, well, courts are traditionally entrusted to interpret and apply the law. However, we have a renewed trend towards questioning the role as final interpreters in the context of authoritarian tendencies. The courts and judges in many countries are being, on one hand side, now asked to show loyalty to state and political powers because they need to interpret the law. And at the second element, well, even the authority of international tribunals to interpret the law is being questioned. Just take the example of England wanting, well, UK wanting to get out of the European Convention, or the US charging people who participate in adjudication of the International Criminal Tribunal in The Hague. And finally, also the introduction of artificial intelligence as a tool which helps adjudication or even replaces adjudication is in a way a distressing challenge to fundamental notion of courts and judges. When it comes to court as a public service, well, again, many officially embrace the notion that courts should serve citizens, but courts in many countries are overwhelmed with the problems, and they are slow and effective, which is extremely visible because life now is getting faster while the courts are working even slower. And then the delays and backlogs often motivate courts to adopt repellent strategies, increasing court fees, aggressive filtering, and the courts thereby, instead of being more a service factor, they become either inaccessible or too costly to deliver justice for all but a few, or too slow to meet the needs of those who can afford their services. And finally, the element of equilibriums. Civil judges are seen traditionally as neutral dispute resolvers in disputes between two parties in a roughly equal process in which parties have equal power and knowledge. It's a so-called triad. However, today more and more cases before civil courts involve a clear imbalance of power, like a symmetrical structure. And we can see now a bulging interest for consumer environmental cases where this is the case. And also the massification and collectivization of civil procedure challenges the court's role as authority that provides everyone the right to be heard. Because in that context, in collective redress schemes, allow only representatives to be heard, whereas the others are just passive bystanders. Yet another challenge to the notion of court. And last but not least, publicity. Publicity is an element of fair trial that is inherent to court activity. Justice needs to be seen to be done, but it is also apparently challenged in many ways. And just one point which I would like to note here from our research is that digitization, which has a horrendous potential for publicity now, in many places, instead of promoting greater openness, rarely produces genuinely open justice. And new paradigm of openness of justice is something that we would need to produce for a new digital age. And this was just a pars pro toto. If Eduardo would like to highlight the other chapters very briefly.
More? 1 minute.
In 1 minute, yes. See, we make it very difficult for everybody.
In the first 30 seconds, we really enjoy working together.
Good.
It was a fantastic group, and we will continue. Secondly, the second issue that I want to mention, you mentioned the idea of civil procedure and values. And we are very worried about this new area in which democracy is under risk. And some of our analysis, because our segment is civil court and independence, and also mean disciplinary proceedings, were very, very interesting in the develop against the judiciary in general and the reaction from the judiciary that sometimes are not the right one. It's a very complex issue, but we pay a lot of attention on the values under discussion. 1 minute, that's all. Thank you very much.
Thank you. We make it very difficult for you all because we actually want you to go to the website and read the papers. And instead of taking questions now, why don't we go straight to Severine? Doreen's comment and presentation, and then I promise you'll get coffee.
Hello again. Our segment is access to justice and cost of litigation with an amazing team. Petra Butler from University of Canterbury, Maria Luisa Vilmarin from the University of Madrid, Ramon Feldrin from the University, Reichman University in Israel, but I didn't know how to change the map. Sorry. Myself from Luxembourg and Belgium, and our wonderful team leader, Wolfgang A. from the University of Munich. I will talk about proportionality in civil procedure, which is not, as you can see, the title of any chapter of our segment. Why proportionality? Well, the issue is not new. You have a pretty good case, Mr. Pitkin. How much justice can you afford? Legal proceedings involve many different costs: lawyer fees, expert expenses, translation, court fees. And one of the most common barriers faced by litigants seeking redress in court is the high cost of bringing legal actions. However, without a normative standard, it's impossible to say in any meaningful way that litigation is too expensive and what is the fair price, le juste prix. But all the comparative studies noticed a lack of proportionality as between the value of claims and the costs that litigants incur in prosecuting and defending those claims, especially at the lower end of the range of claims values. This is where cost efficiency was my chapter 5, and proportionality come into play. States are responsible to ensure that applicants do not have to bear disproportionate costs, and that those who can prove their lack of financial resources are not prevented from seeking redress, but are provided with legal aid. The traditional understanding of access to justice is usually correlated with the issues of legal aid and the finances of the cost of justice. Chapter 6 looks at the evolution and transformation of public funding for access to justice. Public funding is in decline everywhere, leading on the one hand to the development of private funding, but also and above all to the development of less costly procedure. The idea of cost-efficient procedural framework is of paramount importance for effective access to justice. But it also transforms the very notion of access to justice. In principle, it is within the state's margin of appreciation to determine what a cost-efficient procedural framework should look like, and to what extent the taxpayer, or rather the parties, should bear the cost burden. Consequently, the state's margin of appreciation has its limits, where the cost efficiency of the procedural regime undermines access to justice. Rules on cost and funding must therefore be measured above all by whether they are consistent with the fundamental right of access to justice, hence the fundamental importance of cost allocation. And you can find all the chapter here. The specific way access to justice is guaranteed has to vary depending on the way in which the judicial system is designed. The diversity of judicial system thus implies the diversity of forms of access to justice, which is of particular interest for a comparative study. At the same time, the way access to justice is provided may vary even within the same legal system, depending on the nature and importance of the case, as the idea of proportionality well illustrates. That is why, as Professor Hess underlined in his introduction, the quest for proportionality in civil litigation can be seen as the major trend of contemporary dispute resolution. Proportionality has become a keyword in civil procedure, even if it's not easy to define the concept and to find a principle behind the keyword or even the buzzword, especially in a comparative approach. Proportionality is more and more often one of the underlying objectives in civil procedure and in civil justice reforms. There is a clear trend around the world of cost-based reform to promote justice at proportionate cost. Proportionality has become a means through which policymakers implement affordable justice according to the issue at stake in a given case. Proportionality shares some goals with efficiency, such as expediting proceedings and reducing costs, but it also includes normative aspects, weighing financial and non-monetary stakes in a balanced manner, with this duty on the courts and the parties to reach a reasonable solution at the most proportionate cost. Procedural proportionality has two aspects: a macro perspective that could be described as a systemic proportionality of the justice system, which guarantee proportional rather than equal access to justice. This is what I call the policy of proportionality. And the micro dimension, inter partes proportionality, which oblige judge and parties to aim for a proportionate resolution of a given case. And I think this is the meaning of the principle of proportionality. And proportionality had emerged in an environment marked by a growing awareness of the shrinking access to justice caused by escalating fees and delays. Proportionality, as the guiding principle, had its roots in the reform of English civil procedure, especially through the Wolf and Jackson reforms. And I think that Rule 1 of the civil procedure rules is very clear. The idea is to allocate judicial resources proportionally measured against the issues and amount at stake, as opposed to the orthodox strategy to apply the same set of procedural rules to all kinds of disputes. This philosophy of promoting a balance between the means chosen to conduct the proceedings and an accurate outcome for the case spread through the common law world. Australian and Canadian provinces, including Quebec, US jurisdiction, Hong Kong, and Israel, to name but a few examples, have incorporated the notion of proportionality into civil proceedings, recognizing it as a guiding or even a fundamental principle. Proportionality is elevated to the status of a fundamental principle of procedure in common law countries, whereas it seems somehow presumed in civil law countries. The notion of proportionality is increasingly shaping civil procedure, but both in common law and in civil law legal systems. In this sense, it can be seen as a factor of legal convergence of procedural systems. The preamble of Eléonie Droit Models European Rules of Civil Procedure state that the general principle of proportionality in dispute resolution had itself become an increasingly important procedural principle across Europe since the start of the 21st century. This is clear that a growing number of jurisdictions have expressly adopted a principle that costs should be proportionate. And in some jurisdictions, the application of the cost rules delivers a result that is in line with the principle of proportionality without that principle being stipulated in legislation. Under certain rules, parties have a duty to limit costs, especially the cost of evidence, and disproportionate costs are not subject to reimbursement. In some jurisdictions, the court must itself take an active role in assisting the parties in their efforts to keep litigation costs proportionate. It may do so, for instance, by making appropriate proposals for the effective management of the claim by the parties and their lawyers. Proportionality become a keyword in civil procedure. But what does it mean for access to justice? The Supreme Court of Canada underlined that the proportionality can act as a touchstone for access to civil justice. However, except in some jurisdictions, the duty of the courts to administer inexpensive justice is rather a political statement than a concrete rule. The objective of a principle of proportionality are seen as vague, conflicting, and failing to provide guidance to the party's lawyer or judge. There is a real difficulty in giving concrete definition to the concept, and it may be better understood as an aim rather than a tool in itself. Beyond that, there is a more fundamental question. There is clearly an ongoing evolution from access to justice to accessible or affordable justice. It seems clear that efficiency reforms are bringing greater access. But what of greater justice? This is a quotation from this article. Certainly, providing less costly and time-consuming procedural mechanisms will seem logically connected to improving the access of citizens to that procedure. However, the bigger question remains as to whether that same procedure, in the light of its reduced processes, retain the ability to deliver just and accurate outcomes. All reforms designed to reduce the cost of justice also decrease its funding, either by abolishing legal aid or by privatizing the method of dispute resolution. Often, legal aid is excluded for small claims and self-representation becomes the norm. Effective unavailability of legal representation because of financial inability to afford a lawyer must be examined with the principle of equal access to justice in mind. Proportionality must not overlook the underfunding of legal institutions and the increasing commodification of legal markets and legal services. These few remarks suggest that proportionality is an important trend in comparative civil procedure, but this is still more a keyword than a principle. Proportionality invites us to talk openly and in a full knowledge of the facts about what justice costs, and to question more directly the evolution of the economy of legal services, which is restricting access to justice for more and more litigants. However, proportionality is not the only solution for resolving the equation between access to justice and the cost of litigation, since it can conflict with procedural justice. Analyzing the way in which this conflict is balanced in the legal system is the core question of our segment. So come and please read our part and chapter. Thank you.
We do have just a few minutes before coffee for any questions and discussion from these initial presentations. Yes, why don't we go back? Yeah, please.
Yeah, so I'm hesitating who to ask the question for, so maybe I'll ask the question. It goes back to the methodology issues. And so when you're comparing in particular court systems and the cost of litigation, to me, it's so hard to disentangle, right, the specific rules about cost allocation.
Yeah, yes.
Sorry, one is that causing the increased cost from the whole civil litigation system, the role of lawyers, etc. So I really feel that these topics are the ones that are the most difficult to actually make comparative statements. And so I like this idea that proportionality is the key word, or in the other chapter, this idea of the court as playing different functions. But I for myself have always struggled with this, right? How can we look at one thing?
Or that's not codified in a rule, one rule,
right.
you can just
ALI, right, that talks about that. And I guess so reading these chapters, I'm sure will give even more information, data, but we're still, I mean, I'm still always challenged by, you know, how can we actually make an evaluation of what works better, because we can't focus on a single data point. So I'm sorry, there's more comments.
No, this is, and actually this sounds like a question for all of us, really, right? In all of our comparative, how did we manage to locate what is the data point? What is to be compared? And the methodology actually might be easy, but we can't identify what's to be compared.
And depends on the issue.
Yeah, and depends on the issue, of course.
If the issue is too broad, you can do it very easily. When you go to the application of one notion, start to be difficult. Sometimes, for example, one issue that for me is very interesting is this notion of indigenous jurisdiction. You don't have to apply that. I mean, it's very easy. You don't have experience of proportionality in terms of cost in indigenous jurisdictions. And in some other jurisdiction, you don't have it. But depends on how evolved is the system. Right? And when you have many developed systems, you have a problem to select which one you choose.
But actually, I mean, again, I can't speak to the specific teams, but that's one reason why you want to have a team with multiple people, because for each jurisdiction, that person who is very much ingrained in that system can help identify the particular comparable, I think, right? But you have a thought. I'm sorry. No, okay.
Maybe, Margaret, I'd just
Yeah.
like to reflect on the notion of proportionality, as that was one of the points elaborated in the ELI UNIDROIT rules. And that was the segment that the group, which was chaired by Remco Bender and myself, was working on. Would like to emphasize that we had a rather positive attitude towards proportionality in general as a tool which for enhancing access to justice and not reducing access to justice. Proportionality is the notion that enables us to share resources more justly, but also at the epistemological level, the proportionality is not necessarily causing inaccurate results. Of course, if it's proportionality which reduces the needed procedures for coming to results which are pragmatically correct and accurate, then it is the case. But we never thought that proportionality should be viewed in a way of reducing funding.
I deeply agree with that. The fact is that these keywords, this buzzword, could be a very important principle. I perfectly share your point of view, but the fact that it became a political buzzword, very useful to reduce some procedural tools. So, of course, I think it was my starting point, say it's a good thing to have justice at proportionate cost. We will all agree with this idea. The danger behind this idea is that the economic wording can lead to a decrease of funding, and that the procedural justice, the balance between procedural justice and the cost efficiency must be.
And so that came through from comparative studies, right? I mean, so that in some countries, in fact, it had the exact outcome that Alan has suggested, but then for others from your research, it actually was utilized in a very different way. And so that's
but just as a warning, it's not just the costs that are at stake with the principle of proportionality. It's the time, it's the effort, it's the balancing of all of the resources. So simplifying it just to...
No, the question is that I try to distinguish the policy of proportionality and the principle of proportionality. And I think the principle, the procedural principle of proportionality is exactly what you have in mind and what is in the unit principles. The issue is that this principle is much more, and if you see, you can have a look to all the recent reforms in civil procedure. You will find simplification, costs, less. And of course, we all agree that it will improve access to justice to decrease the cost and the time. But the word, the use of proportionality is also used to reduce some, I would say, complete access to justice.
And as proportionality is working as a principle, it's never working alone. And just to give 2 examples of concrete cases I have seen, if you have a slab, this is playing with costs against a weaker party. And here, of course, the idea that parties need to cooperate and to act in good faith are very important principles to counterbalance such a situation. It's also the role of the court which comes into play here. And I have seen a different case, a cross-border case, where it was about discovery and discovery in data documents. And it was about hundreds of thousands of data to be produced, only with the idea, finally, one party cannot afford any longer litigation costs. Here again, it's about cooperation between the parties, good faith, which can be combined with proportionality, and then we come to good results in civil litigation.
But you know, I mean, that's absolutely true as to the proportionality issue, but I'm still kind of intrigued by Genevieve's original question about how you find comparables, right? Which is, and I think that is something that all of you have struggled with throughout this project. And so I don't know if anybody want to share their experience or lessons, and then we can come back. No?
Yes.
Yes.
Maybe it's not so much about data, and it's very difficult to have data on this. But maybe each of you could ask one question. In your case, it's about 5,000 euros. Would there be a finding which costs more for the sales? Or would the judge or the court or whoever decline to undergo fact finding if the mistake is the same as what? Or would the losing party would have to refund the other party if there is disproportion between what is at stake? I think that's a very simple test. Specific. That makes more sense than trying to get access to data about proportionality.
That's right. It's kind of formulating the hypothesis of the question for each.
I can give an example of empirical research. For instance, I mentored a doctoral thesis which has tried to establish whether factually in small claims procedures you have lesser expenses, lesser number of hearings, and whether the steps that are undertaken in small claims are different factually, although in theory they are. There are special rules for small claims. And what our research established is that the differences are minimal and neglectable, and that at least in our jurisdiction which we researched, obviously proportionality virtually does not exist as a principle in civil litigation, not even at the basic level. And then, of course, you can have empirical, anecdotal evidence, case of 50 euros where the court would hold 5 hearings and engage experts, and then the appellate court would strike it as not being precisely enough established. So that again can serve as an indicator of the principle of proportionality.
Yes.
Thank you very much for this fascinating project and small. Mr. General Minister of Proportionality, I would like to ask you, Did you also inquire on the application of the principle in enforcement proceedings, mortgage enforcement proceedings? So, reasonable access to justice in the later stages, and the litigation involving private parties, how can the judge practically use proportionality to address unjust outcomes?
No, I didn't address the stage of enforcement, I must say. But Rudy Laer is here, and I think the
We can talk about it.
oh yeah, you will talk about it. So you have to come back to your
Get it. That's great. Well, all right. I think that we can probably take a break after this very full session. But I like to see the discussion continue as to, you know, what kind of hypothesis, what kind of falsifiable, you know, theories that we can develop and that would ask tough questions. What kind of data do we really want to continue to utilize and look at from this project? And I think that would be really, really helpful, even, you know, maybe in the final sessions. Okay, thank you.